Recently, the Ministry of Electronics and IT has released the Digital Personal Data Protection Bill 2022 for the public to share feedbacks on it. Initially, the deadline to share feedbacks was 17th of December, which has now been extended to 2nd of January. This is the fourth iteration on the bill, which was initially submitted in 2017. What is so special about this bill, and why do we need to discuss about it? It is because of huge penalty. Let's take a look into the penalty section before we move ahead to understand the bill. So if you are sharing your data and you do not comply with the provisions of all applicable laws while exercising your right under this act, or you register a false or frivolous complaint, or you furnish any false particular or suppress any material information, or impersonate another person, or furnished unverified information while exercising the right to correct or erase your data, then you may be fined up to rupees 10,000. If you are a data collector and you do not take reasonably security safeguards to prevent personal data breach, in that case you may be fined up to rupees 250 crores. Yes, you heard it right. And if you fail to notify personal data breach to the board and each affected data owner, or in case of data of a child, you have not taken the consent from their parents, or you took the data of a child that is likely to cause harm to that child, or you undertook tracking or behavioral monitoring of a child, or directing to child targeted advertisement, then you may be fined up to 200 crores. In case you are classified as a significant data fiduciary and you don't appoint data protection officer, or you don't appoint independent data auditor to evaluate compliance under this act, or you don't undertake measures like data protection impact assessment or periodic audits, then you may be fined up to rupees 150 crores. And in case of any other non-compliance of the act, you may be fined up to 50 crores. As per TRI data, total of 1.15 billion users are subscribed for telephones and approximately 700 million users are using internet in India, which may grow to 1.5 billion in the upcoming year. Hence, it is very important to have rules to manage digital data. I am Falguni from Inovatree, and today I will take you through the bill. Stay tuned. This act will be applicable to such data of an individual that can identify the individual, and those data that are either collected online or collected offline and then digitized. This act also applies to digital personal data that is processed outside India in connection with profiling or offering goods or services to the individuals in India. This act does not apply to non-automated processing of personal data, offline personal data processed by an individual for any personal or domestic purpose, and personal data about an individual that is contained in a record that has been in existence for at least 100 years. So before moving ahead, let's understand some of the definitions with relation to this bill, such as data principal. So data principal is an individual to whom the data, personal data relates, and where such individual is a child, includes the parents or lawful guardian of such child. On the other hand, data fiduciary means any person who alone or in conjunction with other persons determines the purpose and means of processing of personal data. Data processor means any person who processes personal data on behalf of a data fiduciary. Now let's understand what are the rights and duties of an individual who is a data principal. So data principal shall have the right to information about personal data to obtain from the data fiduciary. Confirmation whether data fiduciary is processing or has processed personal data. Summary of personal data being processed or that has been processed and the processing activities undertaken. Also, type and list of all data fiduciary where data has been shared. You as a data principal have the right to correct and erase your personal data. You also have the right to register any grievance with data fiduciary if you're not satisfied with its response, or in case of no response in 7 days, you can register complaint to the board. Data principal also gets right to nominate, who shall in the event of death or incapacity of the data principal shall exercise the rights of data principal. While this right provided to you as data principal, you are also liable for few things, which is your duty in accordance with the Act. So you have to comply with the provisions of all applicable laws. You should not register any false or frivolous complaint to the data fiduciary or to the board. While applying for any services, you should not furnish any false particular or suppress any material information or impersonate another person. You should furnish only verified authentic information while exercising the right to correction or erasure. Now that we have discussed about the rights and duties of data principal, we also need to understand obligations of data fiduciary. So data fiduciary can collect or process personal data for a lawful purpose and with a consent from data principal for the specific purpose. Consent here can also be deemed consent, or we will discuss about deemed consent in our next slide. While requesting for the consent or even after the consent has been received, data fiduciary should give itemized notice in clear and plain language containing a description of personal data to be collected and purpose of processing such data. Notice can be a separate document or an electronic form or a part of the same document in or through which the personal data is sought to be collected. Data fiduciary shall also give the data principal the option to access the information. When we talk about consent, it is important to understand what is consent. It means any freely given, specific, informed, and unambiguous indication to the data principal wishes by which the data principal, by a clear affirmation action, signifies agreement to the processing of her personal data for the specified purpose. Any consent that is infringing any provisions of the Act shall be invalid. For example, if you give consent to any company and as part of the contract, the company waives your right to file a complaint with the board. In that case, your consent is valid for the purpose, but waiver of your right is invalid. Data fiduciary shall present the request for consent in clear and plain language along with contact details of data protection officer to respond to any communication for exercising your rights. Where you have already provided your consent, you have the right to withdraw your consent at any time, but the consequences of such withdrawal shall be borne by you, and the withdrawal shall not affect the lawfulness of processing of your personal data before your withdrawal. In such cases, Data fiduciary shall, within reasonable time, seize and cause its data processors to cease and processing of your personal data. You can give, manage, review, or withdraw your consent through a consent manager provided by data fiduciary. This consent manager shall be an entity that is accountable to you and acts on behalf of you, and this is registered by the board. Performance of any contract shall not be conditional on the consent to process any personal data which is not necessary for the process. It is important to note that in any proceeding, data fiduciary is obligated to prove that notice was given to data principal and consent was given by data principal. Consent also includes deemed consent. And let us understand what is deemed consent. Situation where you voluntarily provide your personal data and which is reasonably expected that you would provide such personal data. For example, if you're giving your address, phone number, and name for booking a cab, for any function under any law or for services or for your benefit or for issuance of any certificate or license or permit, the consent would be treated as deemed consent. For compliance with any judgment or order issued under any law, it would be considered a deemed consent. It would be a deemed consent for responding to a medical emergency involving a threat to life or immediate threat to your health. Consent would be deemed consent for taking measures to provide medical treatment or health services to an individual during an epidemic, outbreak of disease, or any other threat to public health. It would be again a deemed consent if it is procured for taking measures to ensure safety of or provide assistance or services to any individual during any disaster or any breakdown of public order. Consent would be a deemed consent for the purposes related to employment, including prevention of corporate espionage, maintenance of confidentiality of trade secrets, intellectual property, classified information, recruitment, termination of employment, provisions of any services or benefit sought by a data principal who is an employee, verification of attendance, and assessment of performance. It would be a deemed consent if taken for public interest, for prevention and detection of fraud, mergers, acquisitions, any other similar combinations, or corporate restructuring transactions in accordance with the provisions of applicable laws. Network and information security, credit scoring, operation of search engines for processing of publicly available personal data, processing of publicly available personal data, and recovery of debt. Your consent would be deemed consent if it is taken for fair and reasonable purpose after taking into consideration legitimate interest of data fiduciary, public interest for the purpose, and your reasonable expectations in regards to context of the processing. Let's now go through the general obligations of the data fiduciary. A data fiduciary shall be responsible for complying with the provisions of the Act in respect of any processing undertaken by it, or in its behalf by a data processor or another data fiduciary. Data fiduciary shall make reasonable efforts to ensure that personal data processed by or on behalf of the data fiduciary is accurate and complete. If the personal data is likely to be used by the data fiduciary to make a decision that affects the data principal or is likely to be disclosed by the data fiduciary to another data fiduciary. Data fiduciary shall implement appropriate technical and organizational measures to ensure effective adherence with the provisions of the Act. Data fiduciary and data processor shall protect personal data in its possession or under its control by taking reasonable security safeguards to prevent personal data breach. In the event of a personal data breach, data fiduciary or data processor shall notify the board and each affected data principal. Data fiduciary must cease to retain personal data or remove the means by which the personal data can be associated with particular data principal as soon as it is reasonable to assume that the purpose for which such personal data was collected is no longer being served by its retention, and retention is no longer necessary for legal or business purposes. Data fiduciary shall publish the business contact information of a data protection officer or a person who is able to answer on behalf of the data fiduciary any question raised by data principal about the processing of her personal data. Data fiduciary shall have in place a procedure and effective mechanism to redress the grievances of data principals. Data fiduciary may, after seeking consent, share and transfer or transmit the personal data to any data fiduciary or engage, appoint, use, or involve a data processor to process personal data on its behalf, only under a valid contract. There are few additional obligations for data fiduciary, especially in case where child's personal data is taken. In such cases, data fiduciary shall obtain verifiable parental consent before processing the data. Data fiduciary shall not undertake any processing of personal data that is likely to cause harm to the child and shall not undertake tracking or behavioral monitoring of children or targeted advertising directed at children. Data fiduciary also has additional obligations in case central government has notified him that he is a significant data fiduciary. Now, what is significant data fiduciary? Central government may notify a data fiduciary as significant data fiduciary based on assessment that shall include the volume and sensitivity of personal data processed, risk of harm to the data principal, potential impact on the sovereignty and integrity of India, risk to electoral democracy, security of the state, public order, and such other factors as it may consider necessary. For significant data fiduciary, this bill lays down additional obligations, and they are appointing a data protection officer who shall represent the significant data fiduciary and be based in India. The data protection officer shall be an individual responsible to the board of directors or similar governing bodies of the significant data fiduciary. The data protection officer shall be the point of contact for the grievance redressal mechanism under the provisions of this Act. Data fiduciary shall appoint an independent data auditor who shall evaluate the compliance of significant data fiduciary, and data fiduciary shall undertake such measures including data protection impact assessment and periodic audit in relation to the objectives of the Act. Now let's look at the compliance framework. So central government shall establish a data protection board to determine non-compliance with the provisions of this Act and impose penalty. To perform such functions as the central government may assign to the board. To issue directions time to time after providing reasonable opportunity to be heard. To adopt urgent measures to remedy personal data breach or mitigate any harm caused. to modify, suspend, withdraw, or cancel any directions issued, and impose conditions that it deems to fit, subject to which the modification, suspension, withdrawal, or cancellation shall have effect. Process that will be followed by the board to ensure the compliances are: on receipt of a complaint made by an affected person or on a reference made to it by the central government or a state government, or in compliance with the direction of any court, or in case of non-compliance, may authorize the conduct of proceedings relating to complaint by individual members or group of members. The board shall first determine whether there are sufficient grounds to proceed with an inquiry. In case the board determines that there are insufficient grounds, it may close such proceedings. In case the board determines that there are sufficient grounds to proceed with inquiry, it may inquire into the affairs of any person for ascertaining whether such person is complying with or has complied with the provisions of the Act. The board shall conduct such inquiry following the principles of natural justice, including giving reasonable opportunity of being heard, and shall record reasons for its actions during the course of such inquiry. For the purpose of conduct of inquiry under this section, the board shall have powers to summon and enforce the attendance of persons, examine them on oath, and inspect any data, book, document, register, or books of accounts, or any other document. Inquiry under this section shall be completed at the earliest. The board or its officers shall not prevent access to any premises or take into custody any equipment or any item that may adversely affect the day-to-day functioning of a person. The board may require the services of any police officer or any officer of the central government or state government to assist it for the purpose of this section, and it shall be the duty of every such officer to comply with such requisition. During the course of the inquiry, if the board considers it necessary for preventing non-compliance with the provisions of this Act, it may issue interim orders after giving the concerned person a reasonable opportunity of being heard. On conclusion of such inquiry, and after giving the concerned person a reasonable opportunity of being heard, if the board determines that non-compliance by a person is not significant, it may close such inquiry. If the board determines that the non-compliance by such person is significant, it shall proceed to impose penalty. At any stage after receipt of a complaint, if the board determines that the complaint is devoid of merit, it may issue a warning or impose cost on the complainant. An appeal against any order of the board shall lie to the High Court. While imposing the penalty, the board shall consider the following points, such as the nature, gravity, and duration of non-compliance, the type and nature of personal data affected by non-compliance, repetitive nature of non-compliance, whether the person as a result of the non-compliance has realized a gain or avoided any loss, whether the person took any action to mitigate the effects and consequences of the non-compliance, and the timeliness and effectiveness of that action, whether the financial penalty to be imposed is proportionate and effective, having regards to achieving compliance and deterring non-compliance with the provisions of this Act, and the likely impact of the imposition of financial penalty on the person. Thank you for staying with us, and in case you have any query, you may reach out to us on the details given here.